Seated. We are back on the record in case number 19-464-83 FC, People versus Omar Morrow. Record should reflect the jury is not present at this time. Anything for the record, Mr. Souter?
Judge, just that I did have a chance to review the jury instructions over the weekend, and I agree to those and have no issue with how they've been presented to me at this time.
All right, Ms. Dye, anything else for the record from you?
Your Honor, I also had an opportunity to review those instructions, and I also have no objection to them at this time. One other thing for the record, I was reviewing with the court reporter on Friday to make sure that all of our exhibits were admitted, and I just want to triple check that exhibits 33, 34, 35 were admitted, and so if those were not, I would move for admission at this time. They were admitted previously, I believe, on stipulation, but I want to make the record perfectly clear.
Well, I only showed 33 was admitted.
And that was what we were wondering.
Okay, so you would admit 34 and 35 as well.
Yes, Judge.
Mr. Souter,
No objection, Judge.
exhibits 34 and 35 will also be admitted. Anything else from either counsel before we bring the jury in?
No, Your Honor.
No, Your Honor.
All right. Please be seated. Good morning, ladies and gentlemen. Mr. Souter, you may begin with your closing remarks.
Thank you, Judge. Just a moment so I can set up. Good morning, ladies and gentlemen of the jury. Again, my name is Drew Sauter. I'm assistant prosecutor for Saginaw County. And I'm the prosecutor, obviously, that's been submitting this case to you for the County of Saginaw against the defendant, Omar Morrow. The point of the closing is for me to summarize and wrap up what I believe the facts and evidence of this case that had been presented to you from last Thursday through Friday. As I stated before, because the burden's on myself, I get to go first. I'll have the first closing. Ms. Dye will have her closing after me, and then I'll have the last word or the rebuttal after she is done. Ladies and gentlemen, this case took place back on August 2nd, 2019. At just before 12:25 in the morning, Lynette Lunsum and Dante Harrison just arrived back to Lynette's house on 802 South Mason Street here in the city of Saginaw. On that day and time, prior to returning to Miss Lumsden's house, they had been out and about, just traveling around, enjoying each other's company. See, August 1st was a Friday, and August 2nd was a Saturday of that year. When they had arrived home, Lynette had left the front passenger seat and went inside to use the restroom. Just after a couple minutes, she returned out where Dante Harrison had been waiting as the driver in that 2005 Buick LeSabre. They exchanged some words. They were debating on where to go and kind of got into an argument. But eventually, Lynette got back into that front passenger seat. When she got back in that front passenger seat, the music was up. They were ready to go back out, maybe drive around a little bit, or go get a last call at a local bar. Nonetheless, Dante started to back that vehicle up out of the driveway. That driveway was located on William Street here in the city of Saginaw. South Mason Street and William Street are the intersection that Miss Lumsden was living on at the time. Miss Lumsden's front porch of the house was on the South Mason Street side, and again, her driveway was on the Williams side. As Dante was backing out of the driveway, Miss Lumsden thought what she heard what she thought were gunshots, but she couldn't quite tell because the music was so loud. Same thing with Dante Harrison. He thought he heard gunshots, but he wasn't sure. At some point in time, Miss Lumsden realized that those gunshots were directed at herself and Mr. Harrison inside that Buick LeSabre. She told Dante, "Hey, gunshots, gunshots." And she turned the music down and started to look around. At that point, she saw an individual coming up the driver's side of that vehicle as it was pulling forward to that intersection of South Mason and Williams. That individual continued to go around the driver's side of the vehicle, kind of in front of it, towards the intersection and towards the streetlight. At this point, Lynette realized that her life was in danger, and so did Dante. It became very real for the both of them, not only because there were shots being fired at the vehicle, but as you saw during the course of this trial, a bullet came in and shattered that front driver's side window. It came right in front of where Dante Harrison was seated and went into the front dash of that vehicle, into the radio. At that point, Dante was so nervous and concerned for his and Miss Lumsden's well-being, he was focused on getting out of there as the driver of the vehicle. He couldn't look around. Although he couldn't look around and see who directly the shooter was, he could see an individual on the driver's side of his vehicle. At that point, he told Lynette, "Hey, look around, see if you can see who's shooting at us." So Lynette starts to look around. Eventually, Lynette states, "Hey, it's Omar, it's Omar, it's Omar." And I won't say what Lynette said during the course of her testimony as to what she directly said when she told Dante it was Omar. But nonetheless, at that point in time, she stated it was the defendant, Omar Maru. At that point, Dante sped away, took a right onto South Mason, and eventually traveled to North Webster Street here in the city of Saginaw. The defendant continued running or walking up William Street further away from that residence. Not only did this impact the safety and well-being of Lynette and Dante, but you heard that 4 other concerned individuals and citizens who lived in the general vicinity of that area called 911. There's 3 different people at roughly 12:25 in the morning that called, "Hey, I'm hearing rapid gunshots, 5 shots, 8 shots, 10 shots. And eventually Tanya Lozano called 911. And at that time, she lived on William Street. And she couldn't really make out who the individual was, but say it was a black male wearing all black walking down William Street. Again, Lynette ID'd the defendant wearing all black hoodie, black pants, black shoes, and a white wife beater that she could kind of see hanging beneath that dark sweater. Now, at that time, as you heard, Lynette and Dante had a no contact order with each other. As their safety was being jeopardized as they were being shot at, they didn't want to turn around and potentially get in trouble for being in contact with one another on that evening. And you heard Dante didn't want to come forward, so he was dropped off on North Webster. Lynette didn't want to say she was around Dante because they didn't want to get in trouble. They didn't want to be the suspects and get in trouble with having contact with one another again when they were just shot at least 11 times. Eventually, after Lynette drops Dante off on North Webster, she calls 911 at 12:42 in the morning. She states, "I was just shot at my home on South Mason. And the defendant, Omar Morrow, who I've known for a very long time, was that individual." Again, she ID'd the defendant and stated he was wearing those black clothings and the white wife beater. Later on, officers arrived at that Rite Aid store on Gratiot Street because Lynette was too afraid to go back to her home at that time. At that time, Officer Collier and Officer Beatty with the City of Saginaw Police Department interviewed and assessed the situation. It was clear at that time that the vehicle, that 2005 vehicle Sabre, was shot from the rear license plate all the way up the driver's side, including shattering that front driver's side window. Eventually, Officer Collier went to the scene and located 9 spent .45 caliber shell casings near that intersection of Williams and South Mason. Lynette further stated that she was too afraid to fully go home that night and ended up staying at a hotel or a motel because of what just happened. Not only did she state that she was being shot at, but either in her 911 calls or her testimony, she said at some point the defendant started to aim and fire at her head. Not just the vehicle that she was in with Mr. Harrison, but at their heads. After this point in time, you heard Detective Inman became involved in this case a couple weeks later. Detective Inman went out and tried to assess the situation and conduct an investigation. He spoke with Lynette on multiple occasions, spoke with the defendant, spoke with Alexis Rios, and then again with Lynette Lunsdom. It's true that at the beginning, the detective did not know, nor did Lynette tell him that she was with Dante Harrison on the early morning hours of August 2nd. But eventually she came clean. And eventually the detective was able to get a hold of Dante, and they were able to get his understanding and his recollection of what happened. Both Dante and Lynette, again, did not want to get in trouble for being shot at and being the victims of this assault. The defendant Detective Inman interviewed the defendant, learned that he could have been potentially with Alexis Rios, interviewed Alexis Rios, and then again interviewed Mr. Harrison and Ms. Lumsden. During the course of this case, you've heard testimony about the detective getting cell phone records for the defendant, for Mr. Harrison, and for Alexis Rios. You heard Detective Sergeant Kahn testify that the location data from those phones on that early morning hours or night were all generally within the same radius or area within the city of Saginaw. Now, although he couldn't pinpoint exactly where someone was when their location data was being shared with their cell provider, they were still within that general area of the 3 addresses that are in question in this case. Again, the victim's residence was on 802 South Mason. A half mile from where she lived, the defendant lived at 1015 South Michigan Avenue. And then just a couple blocks from there was the O'Connell King that came up during the course of this case. That roughly is only about a half mile radius in totality for all 3 of those locations. You heard Lynette testify. It was a 2 or 3 minute drive between their houses. Safe to say that in walking distance too, that would be a short amount of time to cover that distance. Now, that cell phone data was also important because Dante Harrison came up and testified that he was having words and beef with the defendant the week or so leading up to the shooting. And again, that beef and those words were always surrounding the same topic and issue, Alexis Rios. The defendant was getting upset that Dante was contacting Alexis or liking things on her Facebook or having Facebook communication with her, and they exchanged words. And the cell phone records that you saw indicated voice calls and text messages between the defendant and Dante about the week or so leading up to the shooting. But not only that, Dante said there was a lot of Facebook messages or third-party app messages those messages would not be reflected on those cell phone records that we obtained, as Sergeant Kahn testified to. Nonetheless, August 1st, about 5 hours before the shooting, Alexis went over to Dante's apartment. She went over to his apartment with her friend and then was ultimately dropped off at the defendant's house just prior to midnight on August 2nd or August 1st of 2019. Alexis came in and testified that the defendant would get upset when Dante contacted her. Alexis stated that he would get upset. And clearly he was upset in this scenario. Dante and the defendant had exchanged words leading up to the shooting. They exchanged phone calls. They saw each other a couple days before at the rallies, exchanged some more words. Dante stated that he told the defendant to stop threatening him, to stop giving him threatening calls. And this accumulated on August 1st when Alexis went to Dante's house before going to the defendant's house. You also heard statements that the defendant gave to Detective Inman during his interview. And you heard the testimony that Alexis Rios gave when she was here. There was inconsistencies in those statements, ladies and gentlemen. The defendant stated he went to go pick up Alexis between 8 and 9 p.m. on August 1st. Alexis clearly testified that she was dropped off just a little bit before midnight on August 1st by her friend. You also heard the defendant state that no one else came to the house while he was there with Alexis. No one else came to his house when Alexis was there. Well, Alexis came up and testified that multiple of his cousins or friends came over in a Charger, that she could maybe see or hear from a second-story apartment while the defendant went out to go speak with them. Again, inconsistencies, ladies and gentlemen. I'm not denying the fact that the defendant and Alexis were with each other for portions of August 1st into the early morning hours of August 2nd. I'm also not denying the fact that they went to that Econo King at roughly 1:16 in the morning. It was clear. We saw the video. We saw the defendant on the video with Alexis. I'm also not denying that at that time, the defendant was wearing a red and white top with blue jeans. But remember this, folks. That was roughly 50 minutes after the shooting. 50 minutes gave plenty of time for the defendant to get home, whether by vehicle or on foot, to change his clothes, to even sit around for a while, and then go to the Econo King with Alexis. The one thing I am contesting is that Alexis had complete memory and was with the defendant from start to finish when she arrived on the late evening of August 1st. I don't believe she was. Not only do I not believe that she was or has the clear memory of everything that happened on that evening, we heard testimony that just after the shooting on August 2nd, she didn't go in to testify against the defendant, and that case against him was dismissed. She's helped the defendant before, and she came in to testify on his behalf this time around. One thing I forgot to mention, I do apologize, is important about that cell phone data that we collected, or that Detective Inman collected. And the important thing about that is the defendant had roughly a 9 to 9.5 hour break of location data with his cell phone provider. Not only was there that large break in time, he also terminated the phone on August 2nd of 2019. He terminated his subscription on that phone on August 2nd of 2019. Sergeant Kahn gave in his expert opinion that when you have that long break between location data on a phone and the fact that someone terminated their activity on their phone the day of or day after an incident, that normally that's consistent with someone not wanting to be tracked or located by law enforcement. Now, ladies and gentlemen, as a judge will go over with you, and has already at this point in time, the jury instructions on this case. I haven't talked about those so much leading up till now, but I do need to cover that. Because when you go back to deliberate, this is what you're going to have to look at and say, hey, where each one of these elements proved beyond a reasonable doubt. Two of the charges are the same. It's assault with intent to murder, one with the victim of Lynette Lunsdem and one with the victim of Dante Harrison. The first element, that the defendant physically tried to injure another person. As we've heard, ladies and gentlemen, a firearm is a dangerous weapon in and of itself. Not only that, you can locate and determine intent based on actions alone. 11 shots at a vehicle from near point blank range. I think the intent is pretty clear there, ladies and gentlemen. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believe that he had the ability. Again, 11 shots with the firearm. I think that's clear. Third, that the defendant intended to kill the person he assaulted. Again, if you look at the facts and everything of this case, all of those elements speak for themselves. Additionally, for an assault to take place, no actual injury is necessary. As we've stated before, luckily Dante and Lynette were physically able to come here in person and testify in this case because they didn't suffer any injuries based on this shooting. Count 3 is felon possession of a firearm for a specified felony. There's two elements here, and this is one that I covered with you before. The second element has already been stipulated to, that the defendant had previously been convicted of a specified felony. So you don't need to make the determination on that element. The only element that matters on that charge is whether the defendant knowingly possessed a firearm in this state. And then finally, ladies and gentlemen, there's 3 counts of what's called felony firearm, or possession of a firearm at the time of commission or attempted commission of a felony. And in general, I want you to listen to those jury instructions and the elements for that. But basically what that means in layman's terms is that the defendant had a gun when he committed other felonies. As I stated in my voir dire in my opening, this case and how you apply it is common sense. Use your common sense application and what you know about the world to listen to the individuals that came up here and all the evidence that was presented to you during this case. And when you use your common sense and apply that to the charges in this case, I ask you to come back as guilty as charged on all 6 counts of the defendant. Thank you.
Ms. Dye, you may begin your closing remarks.
Good morning. Once again, my name is Lauren Dye. I'm here representing Omar Moro.
May I want to pull that microphone down just a bit.
How's that? Good. My name's Lauren Dye. Again, I'm here representing Omar Moro in the charges brought against him by the state. Once again, I want to thank you for your service here today. I know this situation is unique. Who would have thought in the middle of a pandemic you'd be sitting here serving on a jury? I'm sure that you didn't expect this, but we surely appreciate your efforts here and we appreciate your attendance. I want to take a look at this case from the beginning. And I want you to remember, we don't have to prove anything. We didn't have to present anything, but we did, and I'd like to see what we have to work with here. Again, we're not disputing that a shooting took place. We are not disputing who was shot at. Those 2 items are not in dispute. Government has presented you with a lot of evidence that a shooting took place, lots of pictures with bullet holes and things of that nature. All of that evidence goes towards things that we're not disputing. None of that evidence proves who did it. And that is what is in dispute here. First, we have the misidentification. Government presented you with 5 different witnesses. Only one of those witnesses claims to know who did this. There's 2 witnesses that were present, though. One of them clearly stated he couldn't tell. He couldn't see. He doesn't know. 5 witnesses, only one claims to know. Look at the circumstances of that witness's identification, and the circumstances here are important. It was at night, so it was dark. They were taking on rapid gunfire, and that is not my words, that is the witness's words. Rapid gunfire. The vehicle was attempting to quickly flee. The person that identified him, Lynette Lumsden, says that she was scared for her life. She was having an anxiety attack so bad she might have had to go to the hospital. She even said that she saw the shooter aim for their heads. The amount of duress here, the amount of stress that she was under, in and of itself should call into question the circumstances under which she made this identification. Additionally, she had to look past the driver who was trying to drive to the other side of the street to see this person in the dark through gunshots. It just doesn't add up to me. She says she saw him under a streetlight. But if you remember the pictures that the government presented, the streetlight was across the street from her house. Later on, she goes on to tell you she found 2 casings that the police didn't find in the yard of her house. How's that possible? How's it possible? Was he not standing where she said? Was it more convenient if she said that he was standing under the streetlight to make it more convincing for you? Seems like it. The government mentioned the 911 caller named Tanya, who did call. She was later also interviewed by Detective Inman. They played that 911 call for you from her. She very clearly stated, someone wearing all black, black man, bald. She only maybe walked that back after she was spoken to for some time by Detective Inman. She was very clear on that 911 tape that it was a bald man. And as you can see from the picture that you'll be able to take with you and look closer up in your jury room, Omar's not bald. Lynette reported that Omar was wearing a black sweatshirt, black pants, black shoes, and a white wife beater. She was very specific about that. It was sticking out from the bottom of his black sweatshirt is what she said. That's how she knew. She got that close of a look. But what about it? The government will have you believe that he tried to murder somebody, went back to his house, changed his clothes, and went to the store for some drinks. That seems like a pretty solid plan for somebody who really thought about it, I guess, but he's entertaining a lady here. They walked back and forth to the convenience store. It just doesn't add up. I don't think that makes common sense. Let's turn to the investigation now. Lynette first spoke to the officers on August 2nd, the morning of the shooting. That was the first time she lied. Detective Inman interviewed her on August 15th of 2019. That was the second time she lied. Detective Inman interviewed her again, or at least spoke to her, on August 20th of 2019 when they went to take more pictures of her vehicle. That was the third time she lied. Detective Inman then spoke to Alexis on August 23rd of 2019. And there, for the first time, is where he learned that Dante might have been present. Because Alexis told him. Not because Lynette told him, Alexis did. And Alexis told him because, as you heard her testify, Dante told her. Detective Inman then went on September 3rd of 2019 to interview Dante. Dante confirmed Lynette's lie. Yep, she lied. I was there. Does it really matter why they lied? They lied all the same. After that, on September 4th, Detective Inman went to talk to Lynette again. And only then, faced with the truth, did she change her story. Only when she was required to tell the truth did she. Let's look at the physical evidence they have. Shell casings. That's it. Do they have fingerprints or DNA on those? Nope. Would have been nice if those had been submitted for that. But because they decided to submit them for ballistics first, they ruined the chance for us to learn anything else from those casings. Maybe we would have had more, maybe not. But what we learned from ballistics was absolutely nothing. That's what Detective Trooper testified to, or Detective Inman testified to. We learned nothing, and we lost the chance to learn anything additional. They presented you with several pictures of the scene. Does it bother you that none of them were at night? Does it bother you that you don't get to see the scene in those pictures in an accurate reflection of the way it was that night? Nobody was stopping them from taking pictures at night. Nobody was stopping them from showing you that lamppost. Nobody was stopping them. But you didn't get that here. Does it bother you? They never searched Omar's place. They never searched Omar's vehicle. As such, they never recovered a gun. They never recovered anything linking Omar to this case at all. There is nothing physical linking him to this case. And what about all the people that Alexis identified during her conversation with Trooper Inman? What about Anacella Reyes, Aquarius Beasley, Terry, Joe Smith, Amanda? All of these people might have confirmed or even offered evidence corroborating. Who knows? We'll never know. It didn't bother to even interview them. I wonder why so many things were missed in this case, why so many things weren't done in this case. I point you to the fact that it appears the case was abandoned after they spoke to Alexis, Dante, and Lynette and learned that Lynette was lying. They abandoned the case. They didn't do any further investigation after that. Think about what Alexis had to say. She has no reason to lie for Omar. They're not friends anymore. She doesn't want to have anything to do with them or him. They've barely spoken in the last year and a half. But right is right. And that is why she appeared here to testify in front of you, because right is right and somebody needed to tell the accurate truth. Alexis also testified that she never once heard Omar threaten Dante or Lynette. In fact, the government hasn't actually offered you any proof of the content of any of those communications. We don't know what was actually said per any records. No records were provided regarding the content. No Facebook messages, no screenshots, no physical phones were ever requested, found, or for all intents and purposes, looked for. Let's look at the timeline of this case. At 9:25, the first phone call comes in. I'm sorry, 12:25 a.m. First phone call comes in on August 2nd, 2019. A shooting took place. One of those was Tanya, who identified a bald man. Lynette Lemston didn't call until 12:42 a.m., a full almost 20 minutes later after the first call. Could it be because she was taking care of the lie she was about to tell? She was getting her story together, preparing to deliver it. She called again at 12:59 a.m. to report that Omar was driving around in his Impala with tinted windows. She was very specific about that. She even knew that it was registered in his name. She made sure to mention that. At 1:27 a.m., she called again to say the same thing. Omar's driving around again, this time on Mason Street in his Impala with tinted windows. At 1:16, though, here he is. Not driving around. Here he is walking up to the convenience store. The timeline doesn't make common sense. Ladies and gentlemen, there is enough reasonable doubt here to fill a dumpster. Omar isn't guilty. The evidence said so, and so must you. Thank you.
Rebuttal, Mr. Souter.
Just a moment, Your Honor. Again, ladies and gentlemen, this is the last time I'll be able to speak with you, and then you will go deliberate on this case. As you'll hear in the jury instructions, as you've heard before, anything that I state or that Ms. Dye states is not evidence on this case. It's questions or what we believe the facts are presenting on this case. The people that you really need to listen to and the evidence that you need to listen to is what's been provided through this witness stand and the testimony that individuals gave on this case through this witness stand. If I, myself, or Ms. Dye have ever stated something that was incorrect or different than what was presented through this witness stand, the evidence, and then what the judge tells you the law is, please follow and remember specifically what was stated. One thing, and really the only thing I want to talk about is, Lynette came in here and testified that she didn't see the defendant driving around in that vehicle. It's true on the 911 call, she said that she saw his vehicle driving around, but she clearly stated she could not see him within that vehicle because of the tint and the time of the day. Not only that, Lynette stated she was wearing her glasses that she always wears in the morning hours of August 2nd of 2019. And then not only the street lights over the intersection of Williams and South Mason was on, illuminating the area, but so was her front port light. Ladies and gentlemen, please listen to the evidence and facts, again, that come from that witness stand. And once you do, you'll realize that the defendant is guilty beyond a reasonable doubt of all 6 of these crimes. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based on the evidence, my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you are satisfied by a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should only consider these questions as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. You should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think the testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, did the witness seem to have a good memory? C, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? D, does the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias, prejudice, or personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? G, in general, does the witness have any special reason to tell the truth or any special reason to lie? H, all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, there will be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, a witness or witnesses made statements that may be inconsistent with the testimony here in court. You may consider an inconsistent statement made before the trial that was not under oath, only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statements were made under oath, then you may also consider the earlier statements as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. In this case, the lawyers have stipulated that the defendant had been previously convicted of a specified felony and was ineligible to possess a firearm on August 2nd, 2019. You may consider whether the defendant has a reason to commit the alleged crimes, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crimes. He only has to show that the defendant actually committed the crimes and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witnesses and each piece of evidence and whether you believe them. Then you must decide whether the testimony evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from a witness, Randy Kahn, who's given you his opinion in the field of cell phone technology, cell phone records and analysis, and mapping and plottings. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for the opinion, and whether those facts are true. You should also think about the expert's qualifications and whether the expert's opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You've heard evidence that the defendant could not have committed the alleged crimes because he was somewhere else when the crimes were committed. The prosecutor must prove beyond a reasonable doubt that the defendant was actually there when the alleged crimes were committed. The defendant does not have to prove he was somewhere else. If, after carefully considering all the evidence, you have reasonable doubt about whether the defendant was actually present when the alleged crimes were committed, you must find him not guilty. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at that time. Also think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. We also consider any times that the witness failed to identify the defendant, or made an identification or gave a description that did not agree with his or her identification of the defendant during trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant, as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. In count one, the defendant is charged with committing an assault with intent to murder on Lynette Lumsden. In count 5, the defendant is charged with committing assault with intent to commit murder on Dante Harrison. For each of these charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to kill the person he assaulted. Under count 1 and count 5, you may also consider the lesser charge of assault with intent to do great bodily harm less than murder. To prove this charge, the prosecutor must prove each of these following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. In count 3, the defendant is charged with possession of a firearm after having been convicted of a specified felony. To prove this charge, the prosecutor must prove each of these following elements beyond a reasonable doubt. First, that the defendant knowingly possessed a firearm in this state. Second, at that time, the defendant has previously been convicted of a specified felony. In count 2, count 4, and count 6, the defendant is also charged with a separate crime of possessing a firearm at the time he committed another crime. To prove these charges, the prosecutor must prove each of these following elements beyond a reasonable doubt. First, as to count 2, that the defendant committed the crime of assault with intent to murder, or the crime of assault with intent to do great bodily harm less than murder against Lynette Lumsden. As to count 4, that the defendant committed the crime of possession of a firearm by a felon. And as to count 6, that the defendant committed the crime of assault with intent to murder, or the crime of assault with intent to do great bodily harm less than murder against Dante Harrison. These underlying crimes have previously been defined for you in other instructions. It is not necessary, however, that the defendant be convicted of the underlying crime. Second, that at the time the defendant committed that crime, he knowingly possessed or carried a firearm. A pistol is a firearm. Possession does not necessarily mean ownership. Possession means that either the person has actual physical control of the thing, as I do with the pen I am now holding, or the person knows the location of the firearm and has reasonable access to it. Possession may be so where one person alone possesses the firearm. Possession may be joint where 2 or more people share possession. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about August 2nd, 2019 within Saginaw County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose the foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty of jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Under count 1 and count 5, there are 2 different crimes you may consider. When you discuss count 1 and count 5, you must consider the crime of assault with intent to murder first. If you all agree that the defendant is guilty of that crime, you may stop your discussions and return your verdict on that charge. If you believe that the defendant is not guilty of assault with intent to murder, or if you cannot agree about that crime, you should consider the less serious crime of assault with intent to do great bodily harm less than murder. You decide how long to spend on assault with intent to murder before discussing assault with intent to do great bodily harm less than murder. You can go back to assault with intent to murder after discussing assault with intent to do great bodily harm less than murder if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you wanted to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with the unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you'll be given a typewritten copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The defendant is charged with 6 counts. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any of these crimes, guilty of a less serious crime, or not guilty. I've also prepared a verdict form in this matter listing the possible verdicts for you. Count 1 charges the defendant assault with intent to murder against Lynette Lumsden. Your possible verdicts are not guilty, guilty of assault with intent to murder, guilty of the lesser offense of assault with intent to do great bodily harm less than murder. Once you reach a verdict, your foreperson will sign and date the verdict form. Count 2 charges the defendant with felony firearm. Underlying felony is assault with intent to murder, or assault with intent to do great bodily harm less than murder against Lynette Lumsden. Once again, your possible verdicts are not guilty or guilty. Once you reach a verdict, your foreperson will sign and date the verdict form. Count 3 charges the defendant with possession of a firearm by a felon. Your possible verdicts are not guilty or guilty. Once again, your foreperson will sign and date the verdict form. Count 4 charges the defendant with felony firearm. Underlying felony is possession of a firearm by a felon. Your possible verdicts are not guilty or guilty. Once again, once you reach a verdict, your foreperson will sign and date the verdict form. Count 5 charges the defendant with assault with intent to murder against Dante Harrison. Possible verdicts are not guilty, guilty of assault with intent to murder, guilty of assault with intent to commit great bodily harm less than murder. Your foreperson will once again sign and date the verdict form. And count 6 charges the defendant with felony firearm, underlying felony, assault with intent to murder, or assault with intent to do great bodily harm less than murder against Dante Harrison. Possible verdicts are not guilty or guilty. Your foreperson will sign and date the verdict form. And at this time, I'd like to see counsel at the bench, please. This time, we'll reduce the number of jurors who will decide this case by 2. 2 of you will be excused at this time by random lot. If your name is called, however, please remain seated. Ms. Patrick, just remain seated at this time. And Mr. Baldoff. Now, Ms. Patrick and Ms. Baldoff, even though you've been excused at this time, you are still considered jurors as alternates. And I will still ask you not to discuss the case among yourselves nor with anyone else, nor listen to any news reports concerning this trial, because as alternates, should something occur, you may be called back to continue deliberation with the other jurors, all right? So even though you've been excused, I still want you to follow the same rules and guidelines, okay? And at this time, I'd ask you all to stand and be sworn. You may administer the oath to deliberation to the jurors. All stand, thank you. You may now administer your oath to the law clerk. Ladies and gentlemen, at this time, you may go to my law clerk and begin your deliberations. Thank you. Please be seated. The record should reflect the jury is not present at this time, and after the court had read instructions to the jury, had counsel approach the bench for any additions, deletions, objections, or corrections. Mr. Sauter, I believe you had none.
Correct, Judge.
Ms. Dye, I believe you had none.
That's correct, Judge.
Anything else for the record, Mr. Sauter?
No, Your Honor.
Ms. Dye.
No, Your Honor.
All right, counsel, I would ask that if you're going to leave the building, you have a cell phone where we could reach you in case the jury has questions or you have to return. Until then, we'll stand in recess.